The Public Procurement Bill aims to curb corruption and foster economic growth through more stringent procurement regulations. While it has been welcomed as a step forward, critics argue that it has significant shortcomings in areas like preferential procurement and countering corruption. Tshiamo Sedumedi is a procurement specialist and he's with MNS Attorneys, and he joins us from Johannesburg virtually to allow us to pick his legal brain. Tshiamo, thank you so much for your time this evening. Remind us again, this public procurement bill was felt very necessary for various reasons. From a legal point of view, why do you think it was time for this to be gazetted?
Good evening, Marcelle, and to the viewers. Just one correction. This actually is no longer a bill now, it's an act.
Indeed,
indeed. Act. It was signed into law by the President on the 23rd of July 2022 this year. Even though, despite it being signed into law, it is not yet in force. The President must make a determination as to when would it be effective. But like you said in your introductory remarks, this is a most welcome bill in a sense that for a long time in a country, we had a fragmented dispensation insofar as procurement regulation is concerned. You know, you found MFMA dealing with procurement, PFMA, CIDB, and many other instruments. So for the first time now, we are going to have a one-stop shop, one single act that regulates public procurement in the country. So that by itself is a most welcome step, because now we have a unified way of how we are all going to manage and regulate public procurement in the country. So that is one of the most wonderful introductions that has come up as a result of this act coming into place.
Now, it was signed into law by the President last month, but just this week it's in the news again because some people are starting to speak up and calling for the President to step back from this act, even though he's already signed it into law. One of the comments coming from the Cape Town Mayor, Jordan Hill-Lewis, who says that it will strip away too many of the powers, especially from provincial and other municipal powers, to be able to manage their own budget. What is your reaction to that?
That cannot be entirely correct, because all of this act does, like I said, it codifies what has been there already. So municipalities all along have been relying on the MFMA to regulate their public procurement. That has just been uplifted out of the MFMA into this act. So there's no power that has been taken away from the municipalities. In actual fact, what the act does is simply provides for the minister, or the act itself, it provides a framework within which public procurement must be undertaken. It will still be up to the organs of state, including municipalities, to prescribe their own public procurement policies. That, of course, must be in line with the framework set out by the minister. So there's nothing untoward that is being brought about by this act, because in actual fact, even during the dispensation of the triple PFA, it provided a framework, and the courts have said once the framework is set out in an act, then organs of state on their own accord can then provide their own procurement policies that will then deal with how each organ of state intends, amongst others, implementing preferential procurement. So there's nothing new from the perspective that this act has brought about. It just confirms what the Constitutional Court has already said, that it is up to the organs of state to develop their own policies. So I do not quite agree with the sentiment that this act usurps any powers that were already existing at the level of municipalities or other organs of state, for that matter.
Talk to me about the practical elements. There's talk of a new public procurement office, and I do believe some of the other criticism being that there would be a lag in procurement decisions taking place if there's one office that needs to deal with all of the paperwork. How is that office expected to work?
I don't see this office being materially different from currently what we have as a public. There's an office of the procurement ombuds sitting in at the Treasury. So all that it does, it just sets up a separate office called the Public Procurement Office. Its task is to issue guidelines and instruction notes that will give effect to some of the provisions in the Act. As an example, the Act provides that the Act itself provides a framework, and the minister will pass regulations that guides how institutions must procure. All that the Public Procurement Office will be doing, amongst others, will be to ensure compliance with the Act. Of course, they've got other extensive powers like investigating any breaches of the Act or issuing instruction notes. You'll recall that even currently under the PFMA, Treasury, pursuant to Section 76 of the PFMA, is able to issue binding instructions to organs of state. So that function now shifts out of General Treasury, but now sit within the Office of the Public Procurement Office. So there is no material departure from what we have been accustomed to be doing. It is just now a formalization of an office called Public Procurement Office sitting at Treasury.
How is it hoped that this act will counter corruption?
Look, there's nothing much groundbreaking in the act insofar as spelling out corruption measures. Of course, there are some nuances that they've added. There's a whole chapter called the procurement integrity. But what is significant in that chapter, amongst others, it now gives official, we always hear complaints from government officials or board members to say they received an instruction from somebody above to do things that are untoward. So if an official receives an instruction, be it verbal or in writing, that they feel does not accord with the rule of law, especially the Act, they are now emboldened to refuse to execute the instruction. What all they must do, they must put in writing to the person authority that they object to the instruction, lay out why they can't execute the instruction, and then report the matter to the Public Procurement Office for them to investigate. So now it's going to come mandatory for this office now to investigate any allegation coming from an aggrieved official to say, I have received an unlawful instruction from my superior that will undermine the spirit of the Act. So those are some of the measures that have been put in place. Secondly, for the first time now, we are going to have a situation where all public procurement records are going to be made available to the media, the public, and the civil society at large. So now there will be a set of records that can be easily accessed by members of the public so as to shine a spotlight on procurement decisions. So that is also one of the measures that is being introduced to ensure that at least it unearths some of the misdemeanors that ordinarily would have been suppressed without this thing being put as part in a public domain. Because for now, ordinarily, you have to rely on PAIA and other measures to access such records. But now with this act saying such records must be publicly made available with a specific purpose of ensuring that the media, civil society, and the public are able to easily access such records. So that, we believe, will go a long way as well in terms of unearthing some of the conduct that might be seen as corrupt.
Now, Tshiamo, I believe that you were involved in a case involving a project at Transnet where you advised on and also examined the rather complex procurement processes that were followed there. If this act was in place at that time, how do you think it would have impacted many of those transgressions that you were able to unearth there?
So, ordinarily, that transaction, the members of the public and the media would have been able to have easy access to those records, right? I'm not saying in any way that the act might necessarily have prevented what happened. All that it could have done would have been made it easier for you and I to be able to, at ease, to access those records. I do not think there's any statute that can, with all the good intentions, that can easily then say it will prevent corruption. We can only put measures in place to ensure that such corruption is unearthed. So those officials at Transnet who ordinarily would have said that my boss had made me to sign this thing, even if I was aware that this was unlawful, then at least they would have had that avenue and the protection in this act to be able to stand up and say, I am unable to execute your instruction because it is not in line with Section X and Y of the Act. So it is that would have sort of helped in terms of preventing some of the transgressions that would have occurred at Transnet during that acquisition of these locomotives.
Nice practical example there to end our conversation. Thank you so much for your time and for your insight. Procurement specialist Tshiamo Sedumedi. He is also the MD at MNS Attorneys here.